Hey students, how are you all? I hope you are fit and fine. And today I welcome you in the second part of the lecture of the Indian judiciary and the system, which I started in my previous lecture, which is chapter number 11, and the syllabus is of your 9th standard. So in the previous chapter, we discussed about the formulas and the basic theories related to the Supreme Court, High Court, and also we studied about the qualification of the judge who are actually included inside the Supreme Court and who are also assigned for the High Court here. Therefore, this lesson is all about the detailed theory related to the Indian judiciary and the judiciary system too here. Now, as we saw the pyramid of the Indian judiciary system and we read about the High Court also and Supreme Court also, in the previous lecture, last line was actually explained from my side, which was related with the court of High Court and the person who can be adjusted there as the judge of the court here, what can be the qualifications and all, and how many kind of dimensions he should be working out. Also 62 years will be the last age of his to be working as the judge of the High Court here. So furthermore, if you go in the today's lecture, then we'll be understanding the basic factor related to the judiciary department of the three main functions, which is judiciary impartment, that is we can say original jurisdiction, appellate jurisdiction, and also administrative jurisdiction. Focus on the page number 89, chapter number 11, 9th standard SS. Now see my dear student, original jurisdiction means what? Under the original jurisdiction, we can say that the High Court is actually empowered to do the directions related to some kinds of courts and all. The order is actually withstanding with the including right documents of the original we can say court and the theories too here. Under we can say this kinds of theories, most of the permissions of the high courts are actually coming from the adjusted legal lower courts too here. Therefore, if you go on the appellate jurisdiction regarding the first one, original jurisdiction, then you can understand, my dear, okay, here if the sessions of the court is adjusting with the crime related to murder, related to the any kind of accused punishments and all, then this kinds of cases should be also studied inside the High Court. So let's check it out here. The second point of the phrase, which is known as the appellate jurisdiction. Under the appellate jurisdiction, my dear students, the court like High Court and the court hears the petitions which is actually against the civil and the criminal cases too here. So therefore we can say that which kind of cases can be filed here. Any petitioner or any petition challenging the judgment to the lower court and the tribunal courts which is made more than 4 attempts towards the High Court. In the case of the sessions, it can be actually adjusting the punishment also, and accusation or accused person should be also having some kinds of capital punishment or the imprisonment towards the jail also. Especially in the case of murder, the sessions are longer somehow, but somehow we can say somehow in the normal cases the sessions could be shorter also. So the petitioner who is unsatisfied by the judgment can be also filing the approach towards the High Court or the tribunal court too here. Therefore, we can say that High Court is having a special power upon the important questioning session where the petitioner is including some kinds of administrative jurisdiction too here. Now, see my dear students, if you talk about this kinds of things, then we can say that jurisdiction and judiciary, jurisdiction and all the things are the basic fundamental rules, right? Categorized people where we need to actually get our fundamental theories clear whenever we are asking for the judgment here. Now the third point, administrative jurisdiction, says that each High Court has authority and the power also for the supervising works. For example, we can say subordinated courts are also working, tribunal courts are also working, in the state wise, region wise they are working. Why they are working? Because they can keep reliability inside the state, they can keep smooth government inside the state with crime free state here. Therefore, we can say High Court feels if it is necessary to ask, then High Court can also ask about the case paper with the subordinate courts and all, which can be proceeding more further for the evidence legal benefits from the High Court here. Therefore, we can say that a court can frame some kinds of general laws to control the procedure of the functioning where the court is actually under the jurisdiction and holding the best power to give the right judgment to the person. Now, this is not only exceeding till here. High Court can also guide, my dear students, High Court can also guide the direct subordinate courts too here in the matter of maintaining records, as I said you in my entire in my, we can say, in my previous lectures here. Now the High Court in the Gujarat, if we talk about, is actually located on the Sarkej Gandhinagar. If you go, then you must say this kinds of High Court, which is also, we can say that, at the Sola highway of the Ahmedabad. The High Court occupied special place in any jurisdiction of a state here, where the High Court keep the records. Also judgment are done on the we can say petition files and the evidence and all. Various cases are studied in the future and in the present too here. The pleading cases which are actually in the pending are also somehow case reopened. They have been also focused well here, and the court is actually having punishable contempt act also for the other lower courts who are not doing their duties properly. Therefore we can say that High Court of the Gujarat is actually located at the Sarkej in the Gandhinagar, as well you know that here. Now what are the subordinate courts? See, as I made you understand about the pyramid of the court, my dear student, there are subordinate courts. Now I'll take the name of that, you just need to focus on that here. Now the subordinate courts are also working under the supervision and the guidance of the High Court of any state and the district and talukas also. Fast track courts are there in this category, we can say. POTA courts are there, POTA courts are there, tribunal courts are there, certification special bureau courts are there. Then we can say each of this state is actually divided into administrative purpose, and the units of this kinds of purpose are called the district counseling court also, where we can say consisting a civil court, a criminal court and a revenue court. Every district is powerful packed by this kinds of court here, so that district, state, taluka, village, everything should be developed well here. So that's how small areas, we can say, courts are there. In the small areas the disputes are sort out. It's not like everybody will be going towards the Supreme Court only, so that we need to take care of that. Now what about the district judge? As we read about the Supreme Court judgment, judges, qualification, High Court judge, judgment, qualification. Now I'll be going to the district judge also. Let's talk about the district judge. Now as we live in the Panchmal district, we can say that the appointment and the promotion of any individual post of a district judge is done only by the, we can say, governor of the respective state. And that is how in the constellation with the High Court and the other states courts too here, it means that we can say that if the government is discussing with the High Court and the bureaucracy of the judgmental person who is actually judgmenting already more than 10 years can be also having some kinds of progress in his post and all, but only after the reference of the High Court and the governor of the state too here. Now what kind of qualification we get? There's a question, what kind of qualification we need to get for the judges of the High Court here? A person being appointed as the district judge, all the judgments should be actually legally towards them. So therefore we can say that he should be Indian citizen, as we know that's a general thing. Apart from that, he should also possess a practice of an advocating at least for, we can say, 7 years in the lower court. And also we can say that all the other judges or the other district court judges must be appointed him by the government, and governor can also hire, or we can say appoint this person as a High Court under the constellation regarding the High Court, and there we can say state public service is also playing a special role in that. So according to that rule framed by the constitution, he or she must be promoted or must be somehow, we can say, promotionalized to here. Now the judge who handles, carefully listen, the judge who handles the civil suits is also called the district judge, the civil cases and all. Therefore we can say the judge who handles the criminal case is also called the session judge. Okay, and apart from that we can say that a district court hears the petition, and the challenging judgment of the lower courts also under its guideline. So these all the things are done specially to make the public and the media in the control and trustable too, so that they can support you towards the nature. Literally we can say that all the civil court suits on the we can say of the rupees on the judgment, like 1 lakh or more, than either government can also ask for against the government and all, and for the courts and cases like divorce, then we can say like courts of alimony, then accidental cases and all other cases can be also filed out here. So somehow small cases are studied under the civil court guideline of a district court too here. So we can say that criminal cases are actually studied somewhere else or in the some other sessions here. So the criminal court includes session courts, then first class judgmental we can say magistrate courts, second class judicial, of the imprisonment raising from 3 to 10 year, and the penalty of rupees 5,000 also if anybody is doing any kind of crime, murder and all, then 3 to 5 years or 10 years there should be an imparchment of the jail, and 5,000 or more than 5,000 can be also pay some amount as a penalty too here. Apart from that, we can say that he, if or she is creating a kind of a crime which is not forgivable or which is not adjustable in the social society, then he or she must be imprisoned for the lifetime imprisonment too, that is more than 21 years. So this is how we can see that apart from these kinds of district courts are also playing the dispute related problems, and means they are also solving the dispute related problems too here. And for this all kinds of general theory, we can say that pertaining to the land revenue cases are also studied here. Land revenue cases are there. Then we can say that as per the example, tribunary cases are also there. Then we can say that vehicle accident cases are also there, and all these all cases are also studied under the district level of the court here. So we can say that if you talk about the Gujarat, let's talk about the special Gujarat here. We can say that the professions of the Gujarat Educational Organization Service, that is tribunal, is also actually recovering generally the debates for the protection of consumer rights also. Means in the Gujarat government, Gujarat is trying to make the Gujarat out of corruption. That's how the Money Laundering Act has been also focused here, and somehow the protection for the consumer rights scheme has been also given in this forum here. That's how we can say that in the cases of POTA, P-O-T-A, and there are some kinds of POTA courts also available. That is for the protection of, we can say, the people. So literally we can say all these courts are actually having a different theory to work, and they all are actually objective to run the case factor, where we can say the janta, means the people, are kept in the first priority. So for hearing the cases of POTA and POTA related cases in Gujarat, especially all the courts are, and they have actually gathered importance by the decentral, we can say, decentralizing their administration and also the function which is working independently. It means that in the Gujarat especially, we can say this function is working independently without any kind of pressure, without any kind of partiality, and without any kind of the fear to hear. That's how I'm calling judiciary independent. So later we can say that the function is working very firmly and lawfully, and the people have started talking about the benefits also right now in the Gujarat. So that's how we can say that these kinds of courts are working there in the theory of the concept. Now this is not only the end here, my dear student. You need to understand that if these kinds of things are working, then there must be a Lok Adalat. And yes, there is a Lok Adalat, but how it is working? Let's talk about the Gujarat only, okay? गुजरात स्टेट इज द फर्स्ट टू लुक एट द लोक अदालत. गुजरात स्टेट ही है जहाँ पे लोक अदालत स्टार्टअप किया गया था, आज सब जगह है. Therefore we can say that लोक अदालत is to provide speedy economical justice to the poor people. House yojanas, food, cloth, dwelling, shelter, okay, that is dwelling, medical, health and all, everything is given there. And apart from that, we can say that poor and weaky section, exploited section, lower sections are actually focused here. So under the, we can say, court providing support to the weak people, especially the Lok Adalat are functions, especially, you must listen to this, especially the Lok Adalat are functions and voluntary even on the Sundays too here. It is voluntarized, and the Sunday too the court is open for the poor people. Later we can say that the district and taluka headquarters, as per the convenience, we can say that of the petitioners can be also open at the Sunday, but according to the condition. But the Lok Adalat generally hears the cases of, we can say, accident and related to compensation. किसी दो का एक्सीडेंट हो गया हो तो किसी एक को पैसे देकर अगर मैटर फिनिश होता है कोर्ट के सामने तो आप कर सकते हो, या फिर केस और भी आगे जाना है तो जा सकता है, देयर इज़ नो प्रॉब्लम. देन वी कैन से डाइवोर्स ऑल्सो, एलिमनी ऑल्सो, जनरल डिबेट्स कुछ कर्ज का हो सकता है, देन पर्सनल कंप्लेंट ऑल्सो, देन वी कैन से पुलिस कंप्लेंट ऑल्सो, एक्सेट्रा एंड एक्सेट्रा. सो देयरफॉर लोक अदालत कंसिस्ट एडवोकेट्स ऑल्सो, सोशल वर्कर ऑल्सो, आपके मेरे जैसे कुछ वॉलंटियर्स भी यहाँ पे काम करते हैं. देयरफॉर वी कैन से हियर द केसेस आर सेटल्ड इन सच अ वे एमिशिएबली सच दैट द पार्टीज आर सेटिस्फाइड, the people are satisfied, and many pending cases are also solved out here. Therefore we can say that all the judgment of the Lok Adalat are baked by the law. Baked by the law means हर एक जजमेंट लोक अदालत का स्पेशली इन द गुजरात में संविधानिक रूल्स एंड रेगुलेशंस के अधीन है. इट इज़ वर्किंग अकॉर्डिंग टू दैट. सो दैट्स हाउ वी कैन से दैट लोक अदालत हैज़ नाउ डेज बिकम द सेंटर ऑफ द अट्रैक्शन ऑफ स्पेशली द मिडिल क्लास एंड द पुअर पीपल. एंड दैट्स हाउ इफ यू गो मोर फर्दर देन वी कैन से दैट दिस इज ओनली नोन एज द इंडिपेंडेंस जुडिशरी. चलिए एक पैराग्राफ हिट करते हैं इंडिपेंडेंस ऑफ जुडिशरी के ऊपर। ओके, देखिए इंडिपेंडेंट जुडिशरी क्या है, व्हाट इज द इंडिपेंडेंट जुडिशरी? द इंडियन कॉन्स्टिट्यूशन दैट हैज kept a judiciary independent is working as a firm decisionized case here, and that's how we can say that it is actually fearless from the legislature and also from the executive, the protection fundamental rights and duties and principles too here. Therefore we can say that social, political, ethical terms and conditions are actually obeyed there, and we can say appointment of the judges are also done there. So pay scales, we can say transfer, promotion, specific period of time, everything is focused here, and therefore we can say during the service of judge of any of their behavior, if it is not proper according to the judgment, then he or she should be boycotted also from there. And now we can say that they cannot carry their cases, they cannot plead the cases, and they can be boycotted, they can be discarded from the running time period of their job also before the retirement. Judiciary is important, and that's how we can say that Indian constitution is actually a term of public welfare. What is the term? Public welfare. And therefore we can say that the court is actually working from the past proper, today also, and the future also proper here. So the Supreme Court has treated such kind of matter and the petitions which are given to the settlement of the cases and all very properly, and also we can say that it has also approved the theory of the vigilance inside the judiciary towards the public also. Therefore we can say that at present there are about 3.5 crore pending cases which is actually about to be studied out in our judiciary. So it is like insufficient time and insufficient management also, but somehow Supreme Court can focus on that here, and literally we can say that the number of courts and the judges are and the staffs are actually delaying on the justice, so government can take any step regarding any time here. So the present central government has undertaken the reforming laws over the 1,500 of the old relevant cases also, which is around to be solved out. So slowly my dear student, the government is also trying to clear up the homework. It means the cases which are pending is nowadays, like presently the central government has undertaken the task. Remember, presently the government has undertaken the task of reframing and like one or more than 1,500 of the irrelevant laws and the cases too here. So government is trying to boost up the system of the case and the court too here. Therefore we can say that this lesson is all related with the independent judiciary and the Indian judiciary or the judgmental system too here. I hope you got all the detailed theory and the knowledge from this lesson, and we'll meet in some other lectures related to the new lessons of the other theories here. Till then you can take care, keep revising, be aware of your laws, rights, rules, duties, and don't break any kind of laws too here. Take care. Jai Hind.